All right, you are recording.
Thank you. Okay, it is September 15th, 1 p.m. This is a meeting of the Land Use Review Board. I am the chair, Janet Hurley. I will ask board members to introduce themselves as I see them on my screen here. Brooke,
Brooke Dingledine, board member present.
Sarah,
Sarah Hyde, board member present.
Kirsten,
Kirsten Sultan, board member present.
and Alex.
Alex Weinhagen, board member. Good afternoon, everybody.
Thank you. Any agenda updates from board members? I see shaking heads. Okay. Are there any public comments from anyone on non-agenda items at this time? So anyone present who would like to comment on things not on the agenda? Brooke?
I just want to point out that Renee, I think, has joined us. And so maybe if you could repeat the demuting instructions to make sure that she's able to speak up if she wishes.
They are star, where do we have those?
I can look up the instructions, particular ones, but it should be on the agenda. But it's *6 unmutes yourself on the phone call in.
Yeah, I don't see it on the agenda.
It's not on the agenda.
I have it posted on the
Can I just speak for a minute?
website. Sure. Thomas Weiss has something to say.
Okay, go ahead, Thomas.
*5 is raise and lower hand on the toggle, and *6 is mute and unmute on the toggle.
Thank you.
And if you're joining in the Teams app or through a web browser using Teams, you can use the microphone icon in the top ribbon of the Teams menu to click, and that will mute and unmute yourself as well.
And I see it in the tips for participating on our board meetings and agenda page on our website. So tips for participating, if you open to the Land Use Review Board website and click on the Land Use Review Board meetings and agenda page. Any public comments on non-agenda items? Okay, let's move forward. Consent agenda. Review and approve September 3rd, September 4th, and September 8th board meeting minutes.
I'll make a motion to approve those minutes as revised per our discussion now, if there are any revisions.
I'll second.
Thank you. Any discussion? I'll just note for that last meeting, I was not present for the adjournment vote, so that box needs to be unclicked. And I need to be indicated as absent instead. And I believe there were some text additions. Did those get added?
I have it all in track changes. I can share the minutes documents if you'd prefer to see them on the screen.
I mean, I think we should indicate that we are changing some of the draft minutes with that proposed narrative change. So if you could show that, Maddie, that would be great.
Are you seeing the screen?
I'm seeing a little tiny Maddie, but it's working on showing the screen, I think. There it is. So can you scroll to the change?
This is for September 4th.
Uh-huh. So Alex suggested replacing the draft language with the language that is underlined in red here. Just a little bit fleshing out the detail, right, Alex?
That's right.
And then
Okay.
reflecting
And
that you
then-
were absent for the end of the meeting, Janet.
Okay, great. Thank you. And the other 2 minutes looked fine to me, and I don't think anybody else had any corrections for those.
There were substantive corrections to the September 8th Tier 3 section, so let me pull those up.
Sorry, that's right. Sorry. Again, and Alex proposed those, and again, just to provide more detail, correct, Alex? Was that a yes?
Yes, it's just
Okay.
more detail.
Okay. Same thing. This is a few more paragraphs in the red underlining, and board members have read these proposed changes. Any further discussion on the minutes for these 3 meetings? Okay, all those in favor of the motion, please say aye. Aye.
Aye.
Aye.
Aye.
That is 5. That's unanimous. Those minutes are adopted. Thank you. Next, operations, budget, and legislative updates. We have been talking as a program about the governor's return to office directive. We are working to collect information from all of our staff, and we will be bringing that to the leadership team, collating it, and then the board will be discussing a plan that that we would be implementing before December 1st to meet the governor's directive. This will involve, some expressing to the administration that we do have some space needs. We are getting weekly updates on FAQs at the DHR website. It turns out that all of the questions that we had were already on DHR's list for frequently asked questions. So we are not alone. And bear with us as we work toward a plan to return to office. Budget, we are waiting for salary numbers that Rachel will have early next week, she's hoping. And we have on our next 3 agendas after that as a board to be discussing our fiscal 27 budget. Legislative updates. Pete is working on gathering legislative fixes or tweaks so that we can discuss those ahead of the legislative session to see what we as a board would like to propose get legislative attention in the coming session. I'm going to ask Pete and Rachel and Jenny if they have any further operational budget or legislative matters to update.
Yeah, I go first here. Just a very quick one to note for the board, the Vermont Emergency Management. There's been a number of different projects that have come in through that process. We've been coordinating that approach with the various district offices. These are projects related to flood recovery efforts, aka in a lot of cases buyouts. Most of those are not jurisdictional. In fact, out of the about 110 so far, there really hasn't been one that's been jurisdictional. And we've got about another 25 to go. So there's a pretty big onslaught of projects to be reviewed by the district staff, but they're making their way through those in a pretty expeditious way. So just wanted to let the board know that those were happening.
Thank you, Pete.
Just to follow on to what Janet said about the budget process, there is a new budget system that is being launched this year. It's actually being launched this week in a training environment to financial administrators. So I'll be taking that training this week. That will only give me access to the test environment, and they will only grant us access to the live environment next Monday. So keep your fingers crossed for a smooth rollout for another new financial system this year. That's all that I have.
Not too much to report on the legal side. I will just note for sort of as it pertains to operations that we have gotten 4 appeals in the last month, which is pretty high volume for us. So as we work through those, we just want everyone to keep that in mind. But that's all I've got. Thank you.
Thank you, Jenny and Rachel. So next on the agenda is studies and reports. Let's see. First up, sorry, I gotta find my agenda. Regional Planning Commission application guidelines. So Renee, can you mute yourself? Please, if you can. Sorry. Regional Planning Commission application guidelines review and approval. So we presented this last week on screen during the meeting. And I must have neglected to get a PDF to post with this meeting, or with the documents for this meeting. So I'm going to have to show it on screen again. It will appear almost exactly as it appeared last week. So the changes that we are contemplating involve changing the idea of a plan review committee to designated board member to coordinate the pre-application and application reviews. So we don't need a definition of plan review committee. The other change had to do with Tier 1B map requirements. Instead of making it optional, we would like to see a Tier 1B digital data layer from all the RPCs that have Tier 1B requests. So throughout the document then, I clarified that we need the draft future land use map data as a digital data layer and the draft Tier 1B map data as a digital data layer. So these changes are repeated throughout the document to be consistent throughout. This is the Plan Review Committee changed to designated board member. And then finally, just those 2 changes. And then we also changed the date in the footer to reflect, well, today I changed it, today's date. Last week I changed it to the 8th, but this is now going to reflect the 15th. We anticipate getting the Rutland Regional Plan application, pre-application on Thursday this week. So we're hoping to get this out there today with those few changes and clarifications. So the last page of the document now reflects an adoption history for a revision 1.1 with today's date as approved and adopted and an effective date of tomorrow, with a summary of what those 2 changes were. Sarah.
So we received some comments from Mr. Weiss. And I wasn't sure if you wanted to address those, but I'm happy to just say, we do have a definition actually for community groups. So the specific entities that are required to be notified are spelled out in the definition for community group. And there's also, I think you had gotten the correction that he also caught under 1.004 about tier 1A versus tier B. And I think we picked that up last week.
Yes, I showed this too, actually. Maybe I need to add that to the revision history.
And
that
then
we added, or we tweaked the definitions for those too.
Yep. And then I think he had a question about who maintains the Act 250 jurisdictional tier map. And I think that goes to the map viewer and that the state will be maintaining that.
I'm sorry, what was the question, Thomas's question?
About who maintains the Act 250 jurisdictional tier map?
That will be us, not
Correct.
the state, but it will be the Land Use Review Board.
Correct, not VAPTA. So
Correct, yes.
all right, thanks. I just want to make sure that we touched on the concerns that he brought up.
Yes. Alex?
Yeah, a couple of follow-ups, and thanks, Thomas, for being another set of eyes on this. I appreciate your comments and suggestions. My understanding with regard to who's in charge of the tier maps is that it is us, as we just indicated, but that the regional plans are required to indicate where those certain tiers are, tier 3, for example. They won't be able to do that until we formally adopt rules and delineate where those are. So I think, in my mind, correct me if I'm wrong, Janet, it's in the next go around, the second go around for most of these regional plans, that they're going to have to show, for example, tier 3 areas and approved tier 1B areas, but they can't show it in the first instance when we're reviewing their plans now, because those things haven't been approved yet by us.
Right.
And then Thomas's other question was about the community groups piece that Sarah mentioned. And I want to make sure I'm clear based on his question and concern. The community groups, as we define them in the guidance, we're not actively notifying them of a pre-application review, correct?
I will, if they have made this official request of the RPC. I think that we will, yes.
Well, so the reason I'm asking is that I was under the impression that our job is to coordinate with other state agencies and to provide them notification and get their comments. It's actually the Regional Planning Commission's job to do the necessary notifications that they have in fact filed their application with us. We don't handle those notifications, do we?
That's true, but I would like our pre-application review to be as comprehensive as possible. And if there are groups that have requested notice from the regional planning commissions, statutorily, that notice is only after we have already seen the pre-application. And we want to front load this pre-application review with as much feedback as we can for the RPCs, so that when they go through their adoption process, they have gotten the substantive comments that we could, all of the substantive comments that we could possibly pull together. So I think it behooves us, the regional planning commissions and the public, for us to do that. And it's not necessarily statutorily required, but I feel like it is advisable.
So under the guidelines then, sorry to be dense about this. Once again, thanks, Thomas, for helping me think through it. Which entity will do those notifications, Janet, if these community groups have requested such? Is that us, or is that the Regional Planning Commission?
At the pre-application stage, I will send a comment form to a community group as defined here, saying that we have received a this regional plan application for which you've requested notice. It's not a requirement by statute, but it's something that I think that we should do.
Okay, thanks.
And the regional planning commissions will then be required by statute to notify those entities when they go through their adoption process. They need to notify them of their 2 public hearings and maybe provide them with, copies of the plan and any statutory report that they produce. Is that Thomas with a hand up?
It is. On the mapping of the tiers, my comment is that it's not clear that there won't be conflicts between the Regional Planning Commission's future land use maps and the Act 250 jurisdictional map. What I was suggesting, or what I am suggesting, is that the guidelines make it clear that in case of a conflict or discrepancy, the ones that the Land Use Review Board is using are the ones that actually govern and apply.
So there won't be conflict because the Land Use Review Board is the body that approves the Tier 1A, Tier 1B boundaries. So the tier boundaries are approved by the Land Use Review Board, not by the regional planning commissions. So they will not be, they can propose Tier 1B boundaries and Tier 1A boundaries that we might not approve. But the approved boundaries are those that the board approves, and those are the boundaries that will make up the jurisdictional tier map that we maintain. And that's the only map that will have, that will be controlling in terms of Act 250 jurisdiction.
My Regional Planning Commission mapping person, or the one who's spearheading the future land use maps, senior planner, I think he is, said that they plan to put on their future land use maps, when they get them, the tiers 1A, 1B, and 3. And my concern is just if they happen to use something different than has been approved, then just to make it clear that the one that's been approved by the board is the correct one to use.
Right. I hear your concern, Thomas. So your concern is that a regional planning commission might, after the fact, put some map data up that isn't the official tier, that doesn't reflect the official tier boundaries. All we can do is say that the official tier boundaries are maintained by the LURB, and that particular data layer is provided via the Vermont Geographic Center for Geographic Information, and it's provided on various state web viewers at some point. But we can't, I mean, if in the unlikely event that an individual RPC puts up some different boundaries, I don't think that we're going to be policing that.
And I'm not, I like your suggestion that this is where the official layer is, and I'm not asking you to police. It's just that if somebody comes in and says, well, the Regional Planning Commission's future land use map shows this, you can say ours governs and this is where ours is. That's all I'm asking.
Okay. Sounds good. I think we're on the same page.
I think we are now.
Okay, thanks. Sarah?
Yeah, I'm sorry. I was just going to say, I don't think anything is really necessary to say because ultimately this board is responsible for approving regional plans. So if a regional plan has something in error, it shouldn't pass through our screen without us catching it. And if they add something at a later date that somehow conflicts with the tier maps, it won't be part of their plan until it comes through us and is approved, in which case it shouldn't be approved without us catching it. So I think we're good. We will catch it if it happens.
Sarah?
With that being said, unless there are any other questions, I'd like to make a motion that we approve the amended Regional Planning Commission application guidelines as edited and reviewed today.
Thank you.
Second.
Thank you, Alex. Any further discussion on that motion? Okay, hearing and seeing no hands pop up. All those in favor, please say aye. Aye.
Aye.
Aye.
Aye.
That is unanimous. I will package this as a PDF and get that to Maddie to put up on our website as soon as tomorrow. Thank you for your input, everybody. Am I sharing screen?
No.
Oh,
You're not.
I meant to be
I-
sharing screen.
I was wondering if you meant to do so, or if you were just relying on last week's screen share. You made reference to a couple of minor edits, date.
Yeah, I thought I was sharing screen and I was moving through the document while we talked, but
Your descriptions were so precise, it wasn't
Okay.
necessary.
Okay, great. So I don't need to unshare. I can just close that window. Thank you, everybody. So appeals study discussion. Brooke, do you want to take the lead on this?
Sure. So as promised, Jen and I were able to meet with A&R to discuss the remaining issues of whether or not, for consolidation purposes, we should propose or consider proposing the same option to an applicant to elect to bring an A&R appeal to the LURB for consolidation on the same project, like we are recommending for allowing municipal zoning cases to come over to be consolidated with an Act 250 appeal. And we had a great conversation with the secretary, and Billy and Catherine Gessing was there as well, the general counsel of A&R. So we had a great conversation, and the upshot is that there are so few consolidated or coordinated appeals of A&R permitting. We have seen 2, maybe 3 at most, any specific year that we have observed it. And so A&R is of the opinion that it would not be desirable to come over to the LURB on those few appeals. Given the multiplicity and technical complexity of agency permits, the significant benefit of existing motion practice before the court, which again was something that we were trying to be a permitting authority, not an appellate board about legal issues. So the general sense that the court processes appeals of agency permits efficiently is really paramount here. And for such a teeny docket to require the lawyers to appear in a different venue, even though I'm trying to be very consistent with our rules to be not too different from the environmental division, it really seems like it would not be advisable to suggest such a transfer. I agree with that. I think A&R has very good points about it. And so I would suggest to the board that we not recommend that consolidation option to the applicants for A&R permitting.
Do board members have thoughts about that recommendation from Brooke?
I'm happy to go
I'll
along
just-
with it.
Yeah, me too.
I am too.
Sarah's
Yes.
nodding. So I think we're good to go on that one, Brooke.
Excellent. Now, the other thing that I did want to just put on the board's radar are one of the stakeholders was inquiring about what efforts we're making with the judiciary, and Judge Zoni and I are going to be meeting next week so that we can discuss a number of items and see if there are any other suggestions for expediting the court process without cases being transferred, or even if they are. And as you all are no doubt aware, we had Jim Dumont had suggested a rule change to Rule 5 that would require the statement of questions to be filed with the notice of appeal at court. And that will save 21 days as the time period that you normally have extra time to file that. So that should speed things up. And in my conversations with Judge Zone, he indicated that he's already talked with the environmental judges about that change. They were in favor of it. So I think he's already put that rule change into process, which is great. Number 2 item that I think that we should recommend is on jurisdictional opinion appeals. We should suggest that they go to on the record in the same manner in which we were proposing to take those appeals. If those appeals stay with the court, the rationale is because a JO is married to the facts upon which it is based, it should remain so, and it should not be a de novo proceeding. We should decide the case and the facts as they were, unless there's manifest error or something of that nature. So it's to convert de novo to on the record for JO at the court if they remain there. The third one is adding a judge to the environmental division to speed things up. Judge Walsh testified to that in 2024, but also with the caveat that due process is still the backstop for the court timing in terms of providing a full and fair opportunity. I don't have any financial numbers on that, but we can acquire that as well, and also ask the judiciary, are there any other resources needed, any other personnel or other kinds of resources?
Brooke, what was the testimony Judge Walsh gave last year?
They were asking him how things could be sped up at the court, and he detailed how much that they are working way overtime, weekends, nights. Their caseload is considerable. And so he testified that, you know, they have been trying to push back on scheduling and those kinds of things to move the cases quicker, while still providing the parties the opportunity to sort of map out the litigation. But given the caseload that they're carrying, certainly another judge would be helpful to move the docket quicker. What he was saying was, however, we still have limitations because of our due process requirements.
Mm-hmm. Okay, thanks.
Then the fourth issue that we are kind of looking at to try to figure out is, can the court exercise more control to limit discovery under Rule 2C, which specifies that discovery is that which is necessary for a full and fair determination of the proceeding. But while the court administers the rules under Rule 1 to ensure, quote, summary and expedited proceedings. So it's to suggest that discovery be more limited than just allowing the parties to go do whatever they want, kind of thing. The next one is case management. Continue to exercise.
Brooke,
I'm sorry.
Kirsten had her hand up before number 4. So Kirsten, do you have a comment on something before Brooke continues?
A quick question about consolidating the statement of questions submittal concurrent with the notice of appeal. Were there any practitioners that, you know, raised concerns about that?
Not during the discussions at the stakeholder meetings. I think everybody was sort of on board with it. It's not unusual in other venues. At the Supreme Court, you do a notice of appeal and you have to provide your docketing statement within 10 days, or maybe it's gone to 14 now. But this is, I didn't hear anybody raising concerns about it. And, it's also, you do have the ability to amend the statement later on.
Okay.
It's not
Okay.
locked in. There are opportunities. The sooner the better, of course. The courts don't like you doing that at the last minute, and it's up to them whether or not they allow that.
Thank you.
So just two others. One was case management was continue to exercise control and pushback over scheduling, maybe allowing for delays only for just cause, and as opposed to just sort of letting the parties figure it out and saying okay to it. It has been reported that the judges are trying to keep those schedules more confined, but to continue that process would be important, we think. And then lastly, Supreme Court appeals, which are as of right. You can just file a notice of appeal and go up and have it heard. And that's under rules 3 and 4, of the appellate rules. But there is a discretionary appeal rule, rule 6, that is sort of like the same standard for like interlocutory appeal, which happens before the end of the case. It's only by permission. And 6A goes through the trial court and then the Supreme Court for permission. Rule 6B goes straight to the Supreme Court for determination whether they will take the appeal. That's something I want to talk more with Judge Zoni about. We have talked about that in the past.
So can you explain what it means to be by permission?
Yeah, so what a discretionary appeal focuses on is issues of law. It kind of cuts out the notion, we're going to look back at the evidence and kind of figure it out, were the findings okay. The current model or standard of review is that we were proposing would be great deference. It has to be really incorrect factual findings, not supported by any record evidence, in order for factual findings presently to be, or in our, well, it's either out of the court now or what we were originally proposing for our appeals. And so you can go up and say there's a factual error, no rational jury could find this, no rational person, the evidence that was relied on is no good. So it's a high bar. What we're saying is there's no, if you do a discretionary appeal, it focuses only on the application of the law to the facts. It doesn't go back and figure out that factual premise, I guess is a way to explain it. So if there are important issues of law that need to be determined, then the court's like, yeah, this is really important. They will take the appeal. If the court's like, oh, this is over, the dimensional requirements, or, I'm trying to think of some other opposite end of the spectrum. We will rely on the factual findings below. No, you don't, the law is applied properly to the facts. We're not going to take your appeal. Or we don't think it's an important enough issue that we should take it on appeal.
Okay.
Now,
thank you.
And let me just explain the difference of that kind of appeal. I'm not suggesting that from the LURB. I think we should stick with the review of the facts at the high standard like the PUC has, and then the application of the law has to be rational, can't be discriminatory or that kind of thing. But for the court, what I am recommending, or we're looking into recommending, is to limit that appeal to the Supreme Court, because you have already had your initial permitting process, and then you're going to the court. And on those cases that are going to the court where you've had a de novo review, everything has been looked at twice, Then when it goes to the Supreme Court, make it only permissive. You've had 2 bites at the apple. An actual court has looked at the facts. And so now let's limit the appeal to the Supreme Court. So that's sort of the reasoning behind it.
Okay.
And that's
Thank
the
you.
end of my list to talk to Judge Zoney about. And as we move through those, I'll report back.
Thank you. We are right on time for Tier 3 rule refinement, Alex.
Excellent. Glad that we have time to get back into that, and hopefully enough time to finish the conversation, at least for today, for the stage that we are in. So just quick table setting so everyone here is on the same page. I know the board members are. There's a memo dated September 2nd that I submitted to the board with recommendations on making refinements to the first draft of the Tier 3 rules based on feedback from the board as well as from the Tier 3 working group and our own program staff. So that's the document that we're talking about, and we've been talking about it for the last 2 meetings, September 4th and 8th. And at our last meeting, we made it through the last item on page 4 is sort of where we landed. So I'm going to share my screen and get us back to that point so we can pick up the conversation and keep going. So here's the memo. For anybody else who's who's here today, the memo is also available on our board agenda website along with the meeting agenda. So as I said at our last meeting, I think we concluded the conversation by talking about some of the mapping refinements that need to be made, and specifically talking about selecting an option for the habitat connector road buffer distance. The current mapping shows 2 options, an 800-foot buffer and a 2,000-foot buffer, and those are largely related to the road rule, which will establish jurisdiction starting July 1st of next year on development that creates roads in excess of 800 feet or roads and driveways in excess of 2,000 feet. So honestly, I don't remember that the board expressed a consensus about which of those buffer distances to use. And so I think in my own mind, I'm thinking we potentially continue to show both in the second draft and tell the public that we're still weighing our options. But if there are any further comments about that, with everyone having a bit more time to think on it, I'm happy to listen before moving on to the next item.
Alex, at the end of our discussion last week, I suggested I asked whether some in-between number might make sense. Did you think about that at all? And do you think an in-between number might make sense?
I think it might. It's just that the 800 and the 2,000 are directly tied to the road rule. And what I was trying to explain in the memo was that from a conservative standpoint, in terms of trying to conserve our natural resources, it would be unfortunate if we picked a smaller number and there was some gap for development to occur between where the road rule took effect and where these habitat connectors would create jurisdiction. And we would not want to create sort of a gap or a hole for development to sort of be encouraged to be in that in-between distance. And so the 800 number or an in-between number like 1,200 feet might potentially create a gap like that. And that's why I'm, at least in the memo, I indicated I'm kind of unsure, but I'm leaning towards the more conservative 2,000 foot number, with the understanding that it would occupy a much larger percentage of the state. And that's, that's somewhat problematic as well.
And can you remind us, was it something like 4% or what was it?
Yeah, with the 2,000 foot number, it's as much as 8% of the land
8%.
area.
Okay. And the other one was like 3%.
Yeah, 2 to 3%.
Yeah, okay. Brooke,
So on the gap issue, are we like double triggering? Let's say somebody is wanting to build a road or driveways in that 800 or 2,000 foot area. And so does it like double trigger it? Oh, it's tier 3 and it's road rule at the same time? So that, like, let's say it's 800 feet in tier 3 and they're really going to build beyond that. Is that the gap kind of thing that you're trying to capture?
Well, so
Or are we
the
double triggering them?
So I'm not looking to double trigger anyone. I'm looking to avoid the situation where a development builds 1,200 feet of road and driveway, but it's under 800 feet of road. So it doesn't trigger under the 800 foot of road rule. It's less than 2,000 feet of combined road and driveway, so it doesn't trigger the road rule on the 2,000 feet, but it's 1,200 feet. And so how does that project become jurisdictional? Well, if we set the habitat connector at 800 feet and it's impacting, the initial portion of that, but the house itself is beyond that, then I guess it's more about whether we're going to have portions of a development that are outside of the tier 3 impact area, and what do we do about that? So this question about what distance to use for the habitat connectors, because it's tied to roads, is somewhat wrapped up in another question later in this memo about jurisdictional extent and whether it should include involved lands or not, or just include the tier 3 area itself. Sorry, a little complicated to think about, but yeah.
No, that's exactly where my mind was going, trying to figure out the interaction between those two for sure. Good
Yeah, and
point.
so honestly, this question could go away and we could simply default to the lower number, 800 feet, if the answer to the question later in the memo about jurisdictional extent is that we're going to include all involved lands, even those lands that fall outside of a tier 3 area, in relation to a project. And of course, there's pros and cons to that as well. So it's a little bit of it's a little bit circular, but we have to think about both elements. Kirsten?
So just a quick question to confirm some of the information that was mentioned last week that was just summarized. So the calculation of 2.1 to 2.6% of land cover area was it just for habitat connector based on using 800 feet versus
Correct.
I think you'd given us a range of 6.6 to 8.1% if the 2,000 foot mark is used. And that's only specific to this one potential tier 3 resource area, like habitat connector, right? It's not that those numbers don't add up the other ones.
Correct.
And then the other thing I think I'm understanding from the data is that some of the other map refinements that are recommended will bump those numbers up higher a little bit.
That's right.
Or maybe a lot, like remains to be seen, but they wouldn't go down, they would go up as a result of map refinement.
Yes. Excellent observation. That is true. Yes.
Okay, thank you.
So unless there's some sort of novel, idea or there's some decisions that the board wants to make now, maybe we're stuck in we still need to wait and see on this question.
Alex, I would just point out that your argument against an in-between number is sort of an argument for the 2,000 foot buffer.
Yes, it is.
So
Maybe we should put this on hold and talk about until we talk about the involved land, because I think they really are very intertwined. and one depends on the other for me, I think.
Yeah, I agree. So let's move on. So I'm gonna turn to page 5, scroll down here. So there's one more mapping change that is recommended, and it's sort of an overall mapping change, and it does involve sort of a policy question that I hope you can help weigh in on. And so that is trying to limit the tier 3 areas in and around existing and planned settlement areas so as to not impinge on the potential for tier 1 designations. And this is actually a piece to the statutory charge that we have under Act 181, in that we need to include measures to ensure that no municipality or region is disproportionately impacted by tier 3 designation that would limit reasonable opportunities for tier 1 or tier 2 designations. So the way I read that, maybe you read it differently, but the way I read that is not to say that different municipalities or regions can't have different amounts of tier 3. They can. That's not disproportional impact that the statute's talking about. What it's talking about is that we can't have disproportionate levels of tier 3 that impact the ability to have tier 1 and tier 2 designations in those communities, with my emphasis really being on tier 1, to be perfectly honest, since tier 2 is sort of everything else that's not tier 1 or 3. And so what I've given you for options in the memo are a few different ways to ensure that we're not impinging on any municipality or region's ability to eventually get a tier 1 designation. So option 1 that I suggested was to actually leverage the future land use areas that the regional plans are preparing and that we will be approving. There are 4 that are eligible for tier 1 designations, 1A or 1B. And so that option is to simply exclude those future land use areas, exclude tier 3 areas in those future land use areas. Option 2 would be to leverage the existing legacy designations that many of you are familiar with, the downtown designations, the village center designations, neighborhood development areas, and potentially add a buffer to those existing designation areas, and not having tier 3 areas mapped within those. And then a final option would be to simply remove tier 3 areas when a tier 1 area has been approved by the board. My recommendation is to go big, really, and that is to leverage option 1, leverage those future land use areas, and understand that those are the places in Vermont that we have planned for growth. And that's not to say that sensitive natural resources aren't considered in those areas, but that those are the areas where Act 250 is less important. And so adding jurisdiction through the tier 3 process seems counter to the overall policy vision of what these potential future land use areas were meant to accommodate.
Brooke.
There's an option 4, and that is use it as an overlay, because I don't know that you have any data at all at this point. We haven't even decided really what the critical resources are. But why are you giving tier 1 a pass? In my mind, what you said is exactly the opposite. We are giving, this isn't about, it's about responsible development in the areas we wanted. It's not about a free pass to destroy critical resources. And
Right,
how do we know that anyone is being unduly impacted more than somebody else until we know what we've decided on and what the maps look like?
Yeah, so those are good points, Brooke. But I guess the point I'm trying to make is that these are areas of the state that that municipalities and regions have designated, and we will be approving for future growth. And in those areas, that is the priority. It's not to say that natural resources and critical resources shouldn't be considered, but perhaps they need not be considered through the tier 3 mechanism, but rather through other mechanisms like just normal A&R permitting, municipal permitting, and the like.
Right, and those are downtown centers, village centers, planned growth areas, and village areas that we will be approving, Brooke. So we will have a say in where those are. Sarah, go ahead.
Told that, but let me just respond to that. Are we gonna be told, well, there are natural communities there, they're gonna possibly be wiped out? I mean, what do you, yeah, I know we decide
yes.
on them,
We,
but
Let
are
me-
we gonna
let
get
me-
that info?
Let me respond the reason why I had my hand up is with Tier 1A, if you take a look at Title 10, 6034, the criteria that we're supposed to be using as a board to review and approve Tier 1A areas, the municipality has to identify rare, threatened, endangered species, significant communities, floodplains, a lot of the things that we are looking at for Tier 3, and say how they're going to hopefully exclude these things from their area, or come up with regulations to be able to address. So I think that I'm fine with the approach that Alex is taking, because I think we have other tools in the toolbox to be able to address that within our denser areas that aren't necessarily in Tier 3, but they're in other places. If that makes sense, Brooke?
and
Yes,
and
it's very
also, Brooke,
helpful.
when we are reviewing these boundaries, we will be reviewing them in a map viewer, and we can look at various other natural resource layers and see, you know, what kinds of natural communities or species, rare, threatened, and endangered species might be present in these areas. And we could ask, you know, a question of a regional planning commission that's proposing a planned growth area that has one of those features or one or more. So it can be part of our review before we approve those boundaries. Kirsten.
Yeah, so I understand what the recommendation is, you know, as best I can, although it's not clear the extent of areas that would be eligible for Tier 1 that the recommendation would be looking to exclude from eligibility for Tier 3, but I guess I'm more comfortable with option 3. I mean, I'm looking at it as, you know, if this whole mapping exercise concerns, you know, Tier 3, where are the critical natural resources? And if they're not Tier 1, then they can still be considered for eligibility for Tier 3. So that's just where you know, how I'm also looking at it in terms of this overall mapping question and what areas to include or omit.
So Kirsten, on that one, I think it presents two issues. And one is the one that Alex mentions here, is that every time then that we approve a Tier 1 area, we have to revise the Tier 3 map every single time. And we could be getting Tier 1 requests separately from the regional planning requests on a rolling basis forever. I don't know how many we're going to see, you know, separately through the years, but it could pose a problem. And secondly, the downtown centers, village centers, planned growth areas, and village areas are the areas that are eligible for Tier 1 status. So, and all that, you know, all that a municipality needs to do is opt in for that and make the request. If those boundaries are coincident, or if they, you know, are only involving those 4 future land use areas, I think that we would probably approve, provided that that municipality met the criteria in statute. So it's almost, it's all 4 of those future land use categories are set up to to be Tier 1 A or B areas. mostly B, but so given that and the cumbersome nature of having to change the tier 3 map, and maybe this is a question for Rebecca, our staff attorney, does every change to the tier 3 map have to go through the rulemaking process? Or is there some caveat that can be made such that if a tier 3 boundary was modified, it doesn't need to go through the rulemaking process? I don't know if Rebecca's with us on this meeting, but
It's a
and I
separate
don't
question,
want to
but
put
it's,
her on the spot either, but it's something to consider here.
Yeah.
And sort of weigh that against the fact that downtown centers, village centers, planned growth areas, and village areas are those areas that are eligible to be tier 1.
Yeah, and so
And
Kirsten, I just want to say to you and Brooke, both, I respect the points that you're raising, and I don't disagree with what you're saying. It would be more, it would involve a bit less risk. It would be more conservative from a conserving, natural resources standpoint to just remove tier 3 areas once a tier 1 area has actually been approved by this board. So I get that. I'm looking for simplicity and predictability. And I'll be honest with you, to date, I haven't done as much as I really should have, and the working group, hasn't discussed in any detail how to meet this requirement, that we have measures to ensure that no municipality or region is disproportionately impacted by tier 3 designations. And this is a shortcut. So maybe it's not the right shortcut, but it's the one that I thought, hey, if we did this, I think we could honestly tell everyone in the state that we're trying to treat all Vermonters and all communities equally with regard to this enhanced Act 250 jurisdiction, which is what tier 3 really is, and that we're not going to impinge on the ability of rural communities that maybe have not gone as far down the designation road as some of the more urban or suburban communities have. And we're going to recognize the importance of these regional future land use areas and what they mean in reality. So I'm not married to one particular way, but that was my recommendation, that we sort of start with the policy in mind and allow other permitting systems to do the necessary review and not have Act 250 be necessary within those areas for tier 3 applications. We would still have jurisdiction for larger developments. So the original purpose of Act 250 would not be undermined by this. It's just that the new purpose of location-based jurisdiction would be informed by those future land use areas and, wouldn't be necessary. Act 250 wouldn't be necessary on that basis in those limited locations.
Kirsten.
Well, yeah, just to maybe lastly mention on this topic, I'm not stuck on any particular formula here either. This just seemed like, like you, I think you just sort of said, a blunt instrument.
Yes.
And maybe there's some other more refined way of figuring this out. But I appreciate the trickiness of handling ensuring that there's not a disproportional impact on any municipality or region. So that's, that this would definitely get at that, like the recommended approach. But maybe,
And
go ahead.
just to harken back to what Sarah said, remember that for tier 1A, we will be looking at rare, threatened, and endangered species and significant natural communities as we evaluate a tier 1A request. And for even the tier 1B, for which the only exemptions are housing projects with up to 50 units, right? we are looking at whether, if the proposed future land use area includes flood hazard and river corridor, there need to be regulations in place to appropriately develop those areas in terms of infill development. So as we review these applications as they come at us, we will be looking at these things. Brooke, well, actually, it sounds like Kirsten has a rebuttal or a.
Well, yeah, I mean, just to confirm my understanding, I mean, those reviews occur as the board is reviewing the tier 1A and or 1B designations as a component of regional plan review, but only when those requests occur. And conceptually, I think there'll be far more areas that are one of the 4 designations that are eligible, but that for which those tier 1A or 1B reviews don't happen because they're not put forward for approval as a component of a regional plan.
Right, and so the jurisdictional triggers will be what they are now, basically. Unless somehow the road jurisdictional rule is triggered,
or if there are critical natural resources for which other jurisdiction occurs via a tier 3 designation. I guess that's what we're discussing here. So
yeah, but your observation is right on point, Kirsten. The universe of areas that I'm recommending is larger than the universe of eventual tier 1A or tier 1B designations. And so the Janet's point about like there will be some substantive review of tier 1A areas is accurate, but you're also right, Kirsten, that there will be plenty of areas that are going to be in one of these 4 future land use designations that won't come before us for a tier 1A. And so we won't have that level of review for those areas. So my argument is more about the larger policy initiative that this act launched and for location-based jurisdiction. And yeah, I think we can intelligent people can disagree about to what extent you want to implement that and how. But
you know what might inform this, Alex, is if we have the tier 3 draft map and intersect that with the legacy designations that are currently in place, and see, is there overlap?
That would be
and
great.
If so, how much?
Yeah, there certainly will be overlap. I've done a little looking on that front. Part of the problem with the legacy designations, as I know you, Janet, and you, Sarah, know, because you've been involved in them, they identify a very small portion of a particular growth area.
Yeah.
Village center designations, for example, are focused on just the commercial historic core and nothing else. And so when you look at those designation areas, they're exceedingly small and don't reflect the intent of what a tier 1 area wants to be or can be. And so if we were to use the legacy designations, we'd need to use like the planning area buffer around them and those sorts of things. And I think it would be helpful later to sort of compare what some of the future land use areas future land use area mapping looks like for these 4 types to some of the designation stuff, and we'll get that in the next few months with the 3 regional plans that are coming in front of us.
So if we were to use the current interim exemption mapping, that would be a high end, right? Probably it would be a good estimate of potentially a higher end of what we could expect for these 4 future land use areas. So maybe sort of mid-range, but maybe looking at that and seeing how many of these critical natural resources that we're settling on fall within those interim exemption areas. Maybe that
Yep.
would be telling. Brooke?
So the difference is sort of timing in a sense. It's like either we exempt all tier 1 or we wait until we approve the regional land use mapping, right? It's one or the
So
other.
we're approving all the regional plans before tier 1 or tier 3 goes into effect.
Right, so we got the
So
regional plans.
all of those future land use areas will be in place by the time tier 3 goes into effect.
My
question-
only
Sorry, go
Sorry.
ahead, Brooke.
So the one thing I was trying to figure out is what if there's some really important critical resource like a wildlife crossing that ends up not becoming tier 3 because of that, or whichever one of these options that we choose. Is there like a safety valve or something?
Well, I think that exercise that I suggested could help us there.
Well, but
You
that
know-
exercise, Janet, will just help us identify whether there are a lot of occurrences of that
Right,
situation.
right.
But Brooke's
Right.
question, I think, is more about, okay, there is an occurrence. What happens in that sense?
Right.
And just to keep it simple, Brooke, the answer is it would not trigger Act 250 jurisdiction under tier 3. And therefore that wildlife corridor, if it warranted some sort of protection, review, what have you, would have to get it through another means unless the project was large enough to trigger Act 250 under the current jurisdictional standards or under the road rule. But I think it's really important for us to remember we're living in the Act 250 silo. Act 250 is not the only method by which critical resources in this state are protected, impacts are permitted, and those areas are potentially conserved. Vermont's really good about doing that on a whole host of fronts, from voluntary landowner programs like the current use program to land conservation efforts, from local land trusts to the Vermont Land Trust to municipal and state permitting outside of Act 250. So as much as I know that's our focus, I don't think that we need to be the backstop against any potential impact on an important resource. I think there are others, and it's okay for us
Right,
to make
but-
a policy decision that says we're going to focus our attention and our jurisdictional efforts in these other areas, which frankly are going to represent, I don't know exactly, Brooke, but I'm guessing that when you add up those 4 future land use areas across the state, next year when we know the scope of them, they're going to
It's small.
occupy very small percent of the state, maybe 5% of the state. So I'm not overly concerned that we're missing,
Yeah.
we're going to miss, key ecological resources
Right.
that are going to, bring the rest of the system down.
Right, and these particular future land use areas are historic, already our historic growth centers, our historic centers, and I would be surprised if there are a lot of critical wildlife crossings that need to be preserved in those already established centers. So,
So I was looking for consensus from the board. What I'm getting is that there isn't really one necessarily, but folks are willing to keep the conversation flowing. But it sounds like Janet, Sarah, you two are leaning towards my recommendation. If that's the case, what I'd like to do is I'd like to make the change to the tier 3 rules and the draft mapping along those lines, and then be honest about it when we go to public feedback to say, this is what we're thinking. And it would take tier 3 out of the picture for these areas around, existing downtowns and potential growth centers. What do you think? What do you think, Vermonters, about that?
Alex, how difficult would it be to do that little GIS analysis to see how much they would intersect? in terms of the proposed tier 3 critical resource areas with the interim exemption areas.
Yeah, I don't think it would take too much effort to do that. And I
Okay.
think there's potentially with the tier 3 map viewer updates that need to be made with the second draft, that could be a resource or a reference layer that's sort of maybe laid into it. What we don't have, sorry, what I don't have time for is to do that and then come back to you to have more discussion before
Yeah.
we bring this to the public in
Right.
October.
Right. I
need
think
to-
that's okay. I think it would just be a data point that would be good to have for that public discussion.
Yeah. I'm happy to commit to doing that. So we're transparent about, the debates and the conversations
Yeah.
we're having on this.
And it might be important for Brooke and Kirsten and Sarah and me and you to see. So at some point.
Okay. Anybody have anything further on this one, knowing that we didn't quite nail it shut before we move on?
Looks good.
Okay.
Go ahead.
So I'll continue scrolling. So we're done with mapping. And at the bottom of page 5, there's a section called jurisdiction trigger. And this reflects our conversation at our 4 meetings in July, in which the first draft was roundly panned, where I had suggested a 15,000 square foot disturbance area trigger that the only projects that disturb more than that would be in tier 3 jurisdiction. And so the 2 options that I present are not necessarily the only options, but those are the 2 that I thought about and wanted to get your input on. One would be that it would include any construction of improvements more than 50 feet from the footprint of an existing structure. And then the other option would be construction. It would be any improvements that are not related to the expansion of an existing structure, meaning, if you want to build a garage that's 25 feet or 40 feet from your house, that's a new structure. Under option 2, that would be, you're in a tier 3 area, that would be jurisdictional. Whereas in option 1, it would establish this buffer around the existing structure and basically say anything you do in that buffer is not jurisdictional, even though you're in a tier 3 area. So could be other options, but what are your thoughts?
Sarah.
I think I like option 2, but I think some of the things I brought up before, and maybe there's a more permanent exemption for accessory dwelling units. I think option 1 could be problematic because I think most septic systems are not usually, well, not always within 50 feet of a structure, and I worry that a replacement system for a failed system could be jurisdictional and a trigger. So I think option 2 for many reasons is perhaps the safest, but I just say maybe that 50 feet, and we haven't talked about, I know that there's the list to get through of other things are already statutorily exempt, but I think maybe making accessory dwelling units more permanently explicitly exempt combined with the number 2 would be the way to go.
Gotcha. I understand what you're saying, Sarah. Option 2 is less, more conservative. Less would be exempt from the tier 3 jurisdiction, but then we would tweak the specific exemptions in that other exemption section to allow for the more important things that we do want to provide exemptions to that aren't necessarily based on proximity to the existing structure. Any other board members have thoughts on which way to go?
Kirsten.
Can I just ask a overall clarifying question? So I'm currently understanding that tier 3 jurisdiction would work kind of conceptually, one might say, similar to how requirements of an overlay district would be. Like it's layered on, you've got all the tier 2 jurisdictional triggers that I think would also still pertain in tier 3. And then if a project occurs in a tier 3 area, you know, these other things could trigger Act 250 review. Am I understanding conceptually how we envision tier 3 jurisdiction will occur sort of administratively? And then, you know, if that's understood, I actually think in terms of this specific question, I was thinking more along the lines of option 1, whereby let's say someone had a dwelling and they wanted to add an accessory structure. I mean, if we were going to say you could add improvements up to 15 feet or some specific distance from the footprint of the existing buildings, I don't think it matters if it's detached or attached. Say if someone's adding a garage, like why would we care that it necessarily has to be an expansion of the existing structure?
Yeah. So Kristen, to your,
So it was sort of like a two-part kind
yeah.
of
So
feedback.
to your first question, functionally, you're correct. In terms of the semantics, you're incorrect. So it's not an overlay district. The tier mapping will have exclusive areas of tier 1, tier 2, and tier 3. There won't be any overlapping of those 3 tiers, right? They will be separate areas, but
Yeah,
functionally it's the same as what you said, because the jurisdiction within tier 3 areas will include all of the triggers that are present in the tier 2 areas. It's just that they
Okay,
will
thank
include
you.
additional
Yeah.
triggers as well.
Yeah,
Yeah.
it's probably not the world's greatest analogy, but just kind of, okay,
Yeah.
thank you.
So the road rule is a really good example of that, because it's new jurisdictional, it's a new jurisdictional concept. And when you read the statute, it doesn't say the road rule is in tier 2 areas. It says the road rule is jurisdictional, period, except in tier 1 areas. So
Right.
the road rule applies in both tier 2 and tier 3. And then we're inventing new jurisdictional triggers within tier 3 that go even further.
Well, right, but all of the existing Act 250 development and subdivision jurisdictional framework applies beyond tier 1A and tier 1B with respect to specific units of housing. Like in tier 3, if someone does, you know, 10 units of housing within 5 years, they would trigger by virtue of that existing development definition. And I guess they would also trigger because they're in tier 3. So I'm trying to find an example of.
It's hard to come up with an example. I haven't come up with one either that would trigger under a normal jurisdictional threshold that wouldn't already have triggered under tier 3, which makes sense because the way we're talking about it, especially after the review of the first draft, the board really wants there to be jurisdiction for most development in a tier 3 area. We're just talking about whether there should be a sphere of exemption around, existing structures and potentially some specialized development that, like an ADU, as Sarah suggested, or something else that maybe gets a pass.
Well, the reason I asked to focus on this important detail is because of the way some of these documents are structured. It wasn't immediately clear to me how one would establish whether or not there's jurisdiction in tier 3. Does one look beyond the triggers that are specific to tier 3 to consider the sort of standard Act 250 jurisdictional framework? And I think the answer is yes.
That's my understanding.
Yeah.
And when we had talked about the possibility of reduced criteria review in tier 3 areas where the project was jurisdictional but wouldn't be reviewed under all 10 criteria, that would have made things way more complicated, because then why you triggered might depend on which criteria. But when we talked about that, the board, I think with the exception of Sarah, for the most part said, no, we don't want to go there. So if we're doing the same review without reduced review criteria, it doesn't really matter. You're going to trigger per the tier 3 jurisdictional triggers probably first in almost every single case. But yes, the road rule still applies. That jurisdictional threshold will still apply in a tier 3 area, just like the current or historic Act 250 jurisdictional triggers.
Okay, thanks.
But your second point, I thought was a good one, and because I feel the same way. Like, why do we care whether you can pass a piece of paper between the addition and the existing structure and call it a new structure, or whether you can't pass the piece of paper and they're physically connected? Like, it seems like the impact relates to the distance from the development. And again, what I tried to explain in my memo is that in my mind, it's probably way bigger than that. You know, the actual development footprint of, say, a residential home is probably much larger than just 50 feet around the existing structure. But I got the sense from the board in our prior conversations that you wanted to be conservative about how much area would potentially not be subject to tier 3 jurisdiction around existing homes and businesses. So 50 feet is kind of a small number.
So do you feel like you have clear direction on that one, Alex, or not?
Well, I take lack of comment as general acquiescence, even if there might be concern. So without Brooke and Sarah chiming in, it sounds like we could move ahead. And it seems like there's a little bit of a split, right? Sarah was interested in option 2 and Kirsten was interested in option 1. So sorry, Sarah, you did speak up. It's really Janet and Brooke that haven't really spoken to which option you prefer.
I agree with Kirsten on this one.
too.
So I think we're option 1 bound.
Okay.
Could you
Number
make
one.
a,
Go ahead, Sarah.
could you make a provision to exempt replacement septic systems or something of that nature? Just because I hate to, people will do odd things to skirt around with septic systems. I'd rather have a fully functioning design system in place that's not jurisdictional, rather than having somebody do something odd to an existing system
Yeah.
that was failed to skirt Act 250.
So Sarah, I totally agree with you. And let's talk about that when we get to the exemptions part of this memo, because I think just because we're moving towards option 1 doesn't mean we can't also have specific exemptions for things like septic replacement areas. But let's talk about that. It's another page forward.
Kirsten.
So could I just also, and this is really kind of getting into the weeds more, but it's possible, I think, that there would be some tier 3 areas with existing improvements that are governed by Act 250 permits. It's possible. And so there could be some requirement or, term or condition of the permit that means that even the 50-foot addition requires Act 250 review. Like maybe there's a stream buffer and now they're going to be closer to it, or there's something in that Act 250 permit that governs the use that means that they do have to amend the Act 250 permit, even though under tier 3 we're saying you can go up, we would be conceptually saying you can go up to 50 feet. So I think we just would want to make that clear so people don't run into that circumstance and not know what the correct answer is.
Yeah, good point.
That's a really good point. The rule, I think the tier 3 rule definitely needs to be clear about that. And you're right. We're not going to cancel jurisdiction of if there's an existing permit that's in force. But it should say that. Thanks, Kirsten. Okay, so I'm going to move along. The the last piece to the jurisdictional trigger section, this is the top of page 5, I think, was related to subdivision. And as we discussed in our prior meetings, the board wasn't really interested in establishing tier 3 jurisdiction over subdivision. You really wanted to focus on construction of improvements, actual impacts to tier 3 areas, not just sort of potential ones. But there was this idea that perhaps we could compel a jurisdictional opinion when there was a subdivision that included tier 3 areas, such that everybody would be on notice, that, you know, the district coordinator would issue a JO that indicated where the tier 3 areas were, and that future development in those areas at a later date could trigger the need for a permit. And we talked about requiring that JO in such circumstances, and requiring that it be recorded in the municipal land records. So that's what I plan to write. I'd still need Rebecca to look at what I write and tell me that it passes some, you know, legal muster, but assuming we're on the same page, I'm just going to keep going.
You're on page 6, by the way, Alex.
Okay, thanks. Yes, there we are, page 6. So at the bottom of page 6, we get to the topic that we just talked about, which is jurisdictional exemptions. So this is a list of what I was suggesting, and why don't we just walk right through it? So my first suggestion is not one that stems from any of our conversations, but it's just my deeply held belief that we need to not have jurisdiction over tiny little structures, even if they're in a tier 3 area. And by tiny structures, what does that mean? I proposed 200 square feet. In my former life as a municipal official, in the community of Heinsberg anyways, permits were not required for anything less than 100 square feet. And again, it was a mechanism, but to be able to say, we don't care that you're building a doghouse or a play or a recreational playground set for your kid or whatever. That's not something that rises to the level of requiring permit review. So I still think that makes sense in this context, but I'm not sure that any of you think that, but I wanted to slip it in there and see what you thought.
Brooke.
Yeah, I'm not sure it's necessary with the provision about 50 or whatever number of feet from existing structures that we're doing, because this only ties it to the construction of a structure, and I could go in and clear 5 acres of land and put a teeny little house on it that's less than 200 square feet. So it doesn't do anything to control development other than the actual structure size, whether it triggers it. So I feel more comfortable with the existing situation. You want to put a garden shed? Sure, it's within 50 feet or 100 feet of your house, whichever the thing is. But and then what about the road in, if it's less than 800 feet and, that kind of thing.
I hear you. I will tell you that as, my experience is not sacrosanct or perfect or all consuming, but I'll tell you as somebody who was a planner in a rural community, there are plenty of cases where people build garden sheds or other similar types of small structures well away from their home. And that's going to happen. So we have to understand that if we don't include an exemption like this, we are going to have cases where someone's going to need an Act 250 permit for a 150-foot shed that happens to be, a little bit further away from their house than what we included in the that other provision. You have to be okay with that. It will happen.
Can we put some kind of limit on the amount of land impacted as well, or clearing, or I don't know.
Involved land question again.
Right.
But I also, one of the things, sometimes those exemptions and municipal regulations also tie it to whether you're putting in a permanent foundation. And 200 square feet. Yeah, somebody could put a tiny house on a permanent foundation, and then there's potentially involved driveway, septic system,
Yeah,
etc.
that's exactly what I was just gonna.
Right. And so anyway, to me, I think it needs a little bit more nuance.
Okay. Okay. Sarah, did you have thoughts on this one? I know you're waiting on the next one, but
I'm fine with 200 square feet, as I think that was usual. Most municipalities have that for a shed exemption. And yes, some could be footprints for tiny homes or things like that, but I actually spoke in support of exemptions for ADUs. So I don't want you could get very nuanced with these sorts of things. I mean, how do you differentiate a fishing shanty from a shed from an ADU? I'm just fine overall, I think, with the 200 square feet, recognizing we aren't going to be able to catch everything. But I think that's a good place to start.
okay. Well, since the majority is interested in either not having this or have it with some caveats, I will explore some caveats and see if I can come up with something logical for the second draft. Okay,
Thank
so
you.
the next item is what you were talking about, Sarah, and this is having an exemption for water, wastewater infrastructure. Now, what I put in here is specific to existing structures, non-jurisdictional new structures. See the item above, expansions to existing structures, that sort of thing. Does that cover what you want to see, Sarah, as an exemption for wastewater systems, particularly replacements?
Yes.
Does anybody else have thoughts about, potential unintended consequences?
What if it's not an ADU, Sarah? It's not
So what if I
an
want to add an
accessory
extra
dwelling
bedroom?
unit. What if it's somebody's dwelling unit that they want to build way out in the woods? And it's
This
little,
is for existing structures, though.
non-jurisdictional new structures.
Correct.
So it could be a non-jurisdictional new structure.
Correct.
Right. So this is the involved land question again, right? If the new structure is not in a tier 3 area, but the septic system for it is, how do we deal with that, right? I think that's the example you're talking about, Janet. The
Yeah.
easiest way to deal with that is just to get rid of new structures altogether, right? And and say, forget about it. If it's a new structure, then you're in. If it's a wastewater system related to a new structure,
Right.
you're in. Unless
Right.
maybe it's an ADU, septic system for an ADU. So that would be a quick and simple way to solve that potential wrinkle. But ultimately, I'm really with Sarah that like the public health issues were related to people needing to replace their failed leach fields. I think are actually more important than the incremental or potential impact on a tier 3 area like that. I think we need
I'm
an
just
exemption
talking
for
about
it.
new structures,
Gotcha.
not existing and failed, replacement of failed systems. That's not what my concern is. It just feels like, it could be a little house, but it could have, it could obliterate some small tier 3 area. If it has a driveway and a septic system and, another small garage that is also exempt.
Brooke, did you have a thought on this?
Yeah, I was trying to understand when you were saying they're in, what you meant by that. Are they in tier 3 jurisdiction or they've escaped it? I wasn't clear on what you were saying, but it's kind of a while ago.
Well, it relates to the question of non-jurisdictional new structures. So what Janet's concern was that you could potentially have a new house built that's outside of the tier 3 area. So there's no tier 3 jurisdiction for the house, but they're gonna clear a half an acre for their septic system and their leach field, and that's in the tier 3 area. And so the way, if it were simply to exempt wastewater systems related to non-jurisdictional new structures that are not in tier 3 areas, but the wastewater system is, that could be an impact.
I was actually thinking that the structure was in tier 3, but
Oh,
the new
okay.
structure was in the tier 3 area, and perchance the wastewater system is in the tier 3 area as well. But because the new structure was less than 200 square feet footprint, it didn't trigger. So,
All
and
sorts of
again, I'm just
permutations.
concerned about new structures, not existing that need septic replacements. So,
Go ahead, Brooke.
Wondering if, I think Billy was here and Jen was here. Yeah, they're still here. Do they have any guidance for us? I mean, A&R permits the wastewater, structures. So can you add any help to us, Billy?
I would say like a 200 square foot structure is really small. Like I can't imagine most people living in a house that big. So I don't know that there's a lot of risk generally that comes from that. And I agree. I think making sure that folks have the ability to put replacement septics on their property is important. I think there's for the last like 10 years or so, when a on-site wastewater permit was issued, the landowner had to identify a replacement area as part of that. So there's going to be a lot of properties that already have replacement areas identified. But I think you could just say, I don't know. I'm just rambling here. I don't have much to add, but I think being flexible here, I think trying to nitpick around these little things is going to be a nightmare for jurisdictional determinations and for the process. And if these allowances are too big, you can always refine them in the future. But I think keeping it simple and allowing for replacement septic fields. I don't know that you'd want to allow for a permanent replacement field. They can always get a permit if that's necessary, but maybe as an exemption, a replacement might be a reasonable accommodation. Sorry, that wasn't super helpful. Jen, what do you got? Any good thoughts?
No, I mean, just in terms of other examples, just in terms of other examples in A&R permitting where there's exemptions, stormwater has a 500 square foot exemption for new impervious that is subsequently counted in future permits for larger expansion. So it just may not, the 500 square feet is a temporary exemption until you build out a larger footprint. But just thinking of other permitting programs that have square foot exemptions.
Thanks, Jen. Kirsten, what do you have?
I was just going to quickly mention that I think, Alex, you and I have talked about if you've got a use in tier 3, like you got a parcel land, only part of it's in tier 3, and you've got a project that crosses that boundary. Maybe you've got several houses sited outside of the tier 3 area, non-jurisdictional. Maybe you've got one that's in tier 3. What's the limit of Act 250 jurisdiction in that scenario? And I think to keep it simple for administrative purposes, I would focus the tier 3 jurisdiction to those uses physically located in tier 3. So in the case of, or that support the primary use when in tier 3. So I don't know, maybe this has got a little bit in the weeds, but let's say you have a house in tier 3 and then you've got a driveway and a septic outside of tier 3. I think all of that comes under Act 250 review. But in the case where the house is located outside of Tier 3, but wants to site a wastewater system in Tier 3, I think that Tier 3 infrastructure would be reviewed, like that portion of the project where located in Tier 3 would be jurisdictional. So I think it just comes down to clearly delineating how we're going to do this, because I think we're going to run into, like a lot of parcels where it's only a portion of the parcel that is in Tier 3. So how are we treating projects that sort of, again, are partially located in Tier 3 and partially located outside of Tier 3 on that parcel?
So that,
And I think
these
you
are
kind of go
all-
to like, what's the primary use? If it's a house, where is the house sited? If it's
These
in
are
Tier
all
3, you review the house and all the supporting infrastructure. If the house
These
is
are all-
outside of Tier 3 and you don't have jurisdiction, but maybe the septic is in Tier 3, I think you review the septic system. That's just how I would draw those lines.
That's helpful, and these are all connected. So the next section is on jurisdictional extent, and that's part of what you're talking about. So I hate to force us to go chronologically or in order through this memo, but I got to do it. Otherwise, we won't get through and we'll miss stuff. So save that thought until we get to the next page. But understand that I think you're right, that these particular exemptions for wastewater systems, and the next one mentioned is roads, driveways, and other related infrastructure. It does have something to do with the extent of jurisdiction. So I think I have some sense on wastewater. If there's nothing more on that at the moment, what about this concept of exemptions for roads, driveways, and other related transportation infrastructure that are in proximity to an existing linear transportation piece of infrastructure?
Brooke?
We got a road rule right now. I don't think we should be messing with trying to exempt roads. Makes it more complicated.
I think the example that I like to use is, let's say that there's a private road that serves 6 homes, and it's not under Act 250 jurisdiction today. We map Tier 3 areas to be within a portion of that development's area, particularly along maybe the road that comes into it. And they want to make some stormwater improvements because those stormwater plans were not sort of sufficiently implemented when the development first went in, which is probably true of most development in the state of Vermont. So they want to do some better ditching on the side of their road. They want to put in a small detention pond or some sort of a level spreader to allow drainage to be dispersed. If it's within 50 feet of their existing road, I would like to exempt that. I would like to say you're close enough to an area that's already impacted that if you're doing a transportation related improvement, like something really good like stormwater treatment, or maybe they just want to build a sidewalk on the side of the road, we don't need to be concerned with that because it's close to the road and the improvement that's being proposed is related to that existing infrastructure. That's my thinking on it, Brooke, but it doesn't mean you're not right about not going there, but that's where I was trying to go.
Yeah, I'm just trying to figure out how it works. So it's like if there's an existing road, you can build 50 feet beyond it and continue the road, and that doesn't count on the road rule. And then
so this has nothing to do with the road rule.
Right.
This won't impact the road rule at all. This is about Tier 3 additional jurisdictional triggers above and beyond the road rule. But yes, the way it would work would be any improvements within 50 feet of the existing road that are transportation related would be exempt. So if the person wanted to build a garage, that would not be exempt. That's not related to the road. But if the person wanted to put in a sidewalk, a trail, they wanted to widen the road, they wanted to put in stormwater treatment, they wanted to run a utility line. Let's say they want to bury their utility line and it's going to be, 10 feet off the edge of the existing road. All of those things would be exempt from tier 3 jurisdiction.
Right, but what I'm getting at is the notion of roads. Are you talking about like improving the existing road, or are you exempting 50 feet of road building beyond the existing road? That's what I'm getting at. Because that's where it would intersect perhaps with the road
I think he's
rule.
talking about infrastructure related to an existing road, not extending a road. So maybe just need to clarify that, Alex.
Well, I meant both actually. So
you
if
did.
somebody wanted to lengthen their road by 50 feet or widen their road by 10 feet or put in a sidewalk next to an existing road, yes, it is. I think what you're thinking, Brooke, it's like a 50-foot buffer around the existing road. That would be an exempt area for any improvements related to transportation. And again, it doesn't impact the road rule, right? The road rule is about the development that includes the construction of 800 feet or more of new road or 2,000 feet or more of new road and driveway. This tier 3 provision for an exemption of up to 50 feet wouldn't have anything to do with that trigger.
Yeah, but if I want to build an 849-foot road beyond an existing road, and you exempt the first 50 feet of it, then I can claim the road rule does not apply to me. So I think what I'm saying is
No,
this
I
going
think
to
that's
remove?
not.
The road rule is based on roads in existence as of July 1st of next year. So any roads that add up to more than 800 feet after that date trigger under the road rule. This tier 3 exemption would not get anyone around that.
It's not suggesting, Brooke, that any road extension gets 50 feet for free.
Okay. That's all I was trying to get at. Sorry to spend so much time on it.
No, it's good. These are great questions to understand it.
We need to be clear for everybody. And these are, it wasn't clear to me that Alex was talking about 50-foot extensions. So maybe just, I guess, make sure the language is pretty clear about what we're talking about, Alex. Next.
Sarah?
Oh, wait, no, we have two hands up. Sarah.
I was just going to say, I like this. I think particularly with a lot of homeowners associations needing to do stormwater improvements and other things, it's best to have some compulsory good things to affirm why they should make those improvements and not deterrents. And I think this is enough to try and provide some of those basic things such as ditching, sidewalks, utilities, etc., but without going too far. I think the other thing too, by having exemption within 50 feet of existing, it tries to limit existing impacts and maybe mitigate new ones, because if somebody has a trigger and they're going to come in, they might come in for something greater, versus I think this tries to really focus development close to existing impacts and existing development.
Kirsten?
So, I'm okay with the concept of it's analogous in a way to allowing some nominal expansion of existing structures that would, otherwise be non-jurisdictional in tier 3. You're sort of doing the same thing with roads and utilities. I get that, but I think that a couple things come to mind. I think we have to be careful in identifying what's an existing road or driveway. And I think we would want to sort of borrow from some of the statutory language in the road rule that is quite specific in terms of looking at, for example, farming and forestry logging roads and conversions. And then the other thing that, and this is maybe the civil engineer in me thinks about, okay, well, maybe you have a 24-foot wide road. This is saying you could turn that into, you know, 125-foot wide road, maybe conceptually, because you could go, you know, you could turn it into sort of like, you know, something like a 2-lane is, so I think it needs a little more specificity to ensure that, I don't think that's the intent, right? To very significantly widen roads, and it would be an unlikely scenario, but I think we should make sure that we're addressing, you know, those occurrences as part of this. So, like I'm okay with the concept, but I just want to make sure some of the detail isn't lost, or that some of that kind of detail would be included.
Yes, and those are great points. And yes, being careful about what counts as an existing road or driveway or linear transportation feature. Yeah.
Yeah, and that you could have some reasonable widening. Like you're not gonna, like I said, take some.
Well, so I wanted to respond in two ways. One, I liked your first point, and I agree we need language. I actually don't agree with you on the second point. I think we should set the whatever the buffer is away from this existing development at 50 feet, as I suggested, or maybe it needs to shrink to 25 feet, such that we don't have to have lots of caveats and specificity in terms of facets of the exemption. You know, because it's going to be hard for us. It'll be harder for us to do that level of specificity than it is to just acknowledge that adjustments or additional development in close proximity to an existing road or driveway is fine. And it doesn't matter whether you're widening the road by 30 feet or whether you're putting in a 5-foot sidewalk and a green belt and some street trees, or whether you're doing a large detention pond. We're just going to stay out of Act 250 permitting within a buffer around these existing areas of development. That I would prefer that for its simplicity and for the acknowledgement that we can't anticipate all the potential ways that a current piece of transportation infrastructure might need to be changed over time, whether it's widening or anything else. So I'd rather just give it a blanket exemption and acknowledge that, you know, the impact's already there. But we could certainly change the number if you're amenable to my argument. You know, we could, if you're not comfortable with a 50-foot buffer, you know, perhaps we drop it to 25 or 20.
You're not going to get a lot of room for stormwater improvement in a 25-foot area. Yeah, I'm interested to know what others think.
I'm okay with 50. Sarah's nodding.
Okay,
Brooke is
sort of nodding.
not sure yet.
Yeah. Okay, well, thanks for hearing me out. I understand the desire to keep it straightforward.
Yeah. Well, also, just so everybody's on the same page, I'm just trying to make some changes to get to our second draft, which is something we put in front of the public. We're not done with this yet. So once we get some public feedback, we'll be talking about this again later this year, and none of this is the end of the decision making. So
yeah.
All right, well, then the next item is related to agricultural and forestry logging practices, including related access. And as we all know, there are certain exemptions in our Act 250 program for these practices. And the input from the working group is to carry those into the Tier 3 areas, as we've discussed previously. But to be specific about them as well, in the same way that the road rule is somewhat specific about them, and yeah, to just be clear about that. So, any thoughts?
Brooke.
I thought long and hard about this, and we mulled it over during the wood products manufacturing study. And I appreciate the exemption and the purpose behind it. My only concern goes to the forest block connectors. That is not something that we can really rely on AMPs if we don't want those areas deforested, assuming that's correct. I'm not even sure that that's, I'm throwing that out there. We want to preserve those forested environments. So that's my concern. I think there's a conflict there because they would be engaging in, and so maybe, Billy just put his camera on. Maybe he can weigh in on that to help me feel more comfortable with it.
Well,
Oh, he just put his camera off.
Oh, no.
Yeah,
Go away,
before
Billy.
you put him on the spot, Brooke, I just want to say, Forest Parks and Recreation has been making the point since I joined this organization that development and forestry and logging are not the same thing. And I 100% agree with them. Forestry and logging is about changing the where a forest is in its successional pathway over time, right? So it's bringing the forest back to an early successional standpoint, but it allows for that forest to then grow and come back into a different phase, whether that's young forest, mature, old growth someday, whatever. That's really different from clearing a site and then developing it for a quarry or for a subdivision or what have you. And wildlife corridors, as they're mapped in the Vermont Conservation Design, it doesn't matter what successional stage they are in. And in fact, the statutory definitions that we've been given for the Criterion 8C work tell us that it doesn't matter what successional stage a forest is in, it's still a forest. And so, yes, there might be an impact on wildlife movement over a short period of time while that area that was harvested is regrowing. But that's a blip, logging sites, in all honesty, mostly look terrible in the first year that they've been harvested because of the nature of that, how that works. And 3 years later and 5 years later, they look a whole lot different. And I don't know if you ever walked by sites where they have interpretive displays that tell you when this patch of woods was last cut. It's remarkable to see how fast those areas regenerate, and they are forests the whole way through. They just are in different successional stages.
Great info. Thank you. I feel better. Maybe
Billy, do you have
wants-
anything to add to that?
I think Alex has learned everything there is to know about this topic and articulated that well. Yeah, I think we have long held that forestry for kind of forest management purposes is not development, that it's intended to maintain forests where forests are currently growing through different stages of succession. So for all the reasons Alex articulated, we support this. I think there is a difference between forestry and site preparation or clearing for development, and those sorts of activities, should trigger it. But that's always a challenge we run up to in Act 250 and other regulatory programs. When is something forestry, when is something site preparation, and every once in a while we do run into that issue. But largely speaking, we know a forestry operation when we see it and support this exemption here. So thank you.
Any concerns about agriculture?
Okay. Can we move to
right, then.
the next and last one? I think it's the last one. Yes, it is. Then we get to jurisdictional extent. So, right now, as you all know, there are lots of Act 250 exemptions built up over time, and they're contained in the statute in different places. In section Title 10, section 6001, 3D and E, we talk about what development is. and then we say what's not development. And so there's a bunch of essential exemptions in that section. Additionally, which I didn't indicate in the memo, there's section 6881, which has a whole host of more straightforward exemptions. And so the question is, should we carry those through to tier 3 areas, or should the tier 3 rules try to rewrite some of these statutory exemptions from Act 250 because tier 3 is different? And I think two things. One, there is a legal question as to whether we have the authority to even do that, right? The legislature wrote these exemptions into statute, and even though we've been granted tier 3 rulemaking authority, I don't know that we can unwrite them, even in a tier 3 area. I don't have an answer to that. I don't know that we really need to talk about that because I think our legal team can get that answer for us. The other question is, why wouldn't they? If we do have the authority to monkey with them, why would we? Like some of these exemptions make sense, even in a tier 3 area. Maybe not all of them, but a lot, in my mind, a lot of them do. And so in any case, my recommendation is let's just keep it simple. Look through those exemptions in statute. You've got the list. And if you're comfortable with those being exemptions in the tier 3 area, then let's just carry them through. And what we talk about in tier 3 is any special exemptions like the ones we just finished discussing and jurisdictional triggers, which we've already talked about. But what do people think about that juicy topic of exemptions in tier 3?
Brooke?
Yes, I agree with you. Nice bright lines, keep it the way it is.
Yes. Sarah?
Agreed.
And, this over time, there could be reconsideration of particular exemptions that might turn out to be problematic. I don't know how likely that might be, but it's something that could be considered in the future. But I agree. Kirsten, do you want to voice an opinion?
Well, I had in mind that we would wait to hear from our attorneys and go through the specific exemptions. But if the four of you have, reached a conclusion that you want to just continue to retain them as written in tier 3, that's kind of a majority perspective on it. So are we going to hear from legal on this though? Like has that inquiry occurred?
I've already asked the question, and regardless of what the majority or even all of us think, I want an answer to that from our legal team, because I suspect that question may come up in our public meetings, and I don't want to be flat-footed. I want to be able to tell folks if we're not actually allowed to tinker with that.
Yeah. Or if we are, yeah.
Yep.
Yeah, in case we want to do something in the future, we do need to know.
Yeah.
Okay. I will report back on what our legal team says to that specific question. So,
Alex,
we're done.
I'm just going to say we have a little more than 5 more minutes, 7 minutes actually, on this topic before I think I need a break to go, do something else for a few minutes.
Yep. So you're running the meeting, Janet. Do you want to continue to the last portion here of jurisdictional extent and site-specific resource delineation, or would you like to take a break now?
I think this is going to take more than 7 minutes, don't you?
Yes.
So I think I would like to take a break now and start back up again at 3:20. Does that sound good? Or yeah. Okay.
Okay.
So Maddie, can you put up the board is taking a break thing, and we'll be back shortly. Certainly we'll all be back.
Stop sharing your screen.
Oh yeah. Okay, thank you. We'll be
Thank
back shortly.
you.
Hey, Eric. Pretty good. Waiting my
Chris,
turn
you're
on
not
some.
muted.
Oh, sorry. Talking to my son.
Okay, it's 3:20. I see a quorum of, I see all of us. So Alex, would you like to continue?
Yes, please. So I'm sharing screen again. We're on the next section of jurisdictional extent, which we talked about earlier, sort of comes up again and again. And you know how I am. I'm trying to keep it simple for you. I'm giving you two options. Do we just cover development that's within a tier 3 area, or if a portion of the development is both inside and outside, do we capture all of it? I was recommending option 2, which is to capture all of the involved land, but I think Kirsten and I talked about this, and Janet and I did too. And Janet knows I'm a little undecided, but I like Kirsten's idea. I like the idea of saying the jurisdiction is for what's in the tier 3 area, but if there's infrastructure that supports that, that is directly related to that we would potentially have that be jurisdictional as well, even if it's outside of the tier 3 area. Kirsten, the example you gave was, a house that a portion of that is in the tier 3 area, and perhaps the driveway or the road that supports that house is outside of it, or what have you. The only uncertainty I have with this that Janet and I discussed offline was, part of the intent with tier 3 and to some extent with the road rule is to encourage developers to consider these resource areas and the amount of road and driveway they're creating, and try to do smart site design and to avoid those areas. And what I don't want to have happen if we'd use the involved land concept is to penalize somebody for putting 90% of their project outside of a tier 3 area, but one house site out of 3 or 4 happens to be in, and then we reach out and declare jurisdiction over the entire project. So how we balance that, I think, is important. Interested to hear your thoughts.
Let's put Sarah on the spot. She's been too quiet today.
I know you're recommending option 2, Alex, but I'm leaning towards option 1. Because just of what you said, if there's that one thing, that one small piece, and it's hard because, I think Krista has advocated for more specificity. And with something like this, you could add a lot more specificity to hone in on the points that you just said, Alex, in terms of, if there's, let's say the majority of everything is located outside the tier 3 jurisdictional area, but you have one component, one thing, let's say it's the stormwater system, best spot on the site to place it, or it's a replacement area or something like that, and it triggers it. I worry about the unintended consequences of site design around jurisdictional triggers. And I think lacking greater specificity, option 1, I think addresses that concern for me.
Brooke, I saw your hand go up. Do you want to opine on this?
I'm in agreement with Sarah. I appreciate Kirsten's thoughts on it, but I think it does. We're worried about the critical resource and what's impacting that. And so if we're not going to give a pared down Act 250 application, they got to go through all the criteria. I think it should be limited to those structures or development that is impairing or potentially has an adverse impact on the actual resource. I agree with everything Sarah said also about the design. And I think it's yet another analysis, more complication about, okay, it's tier 3, what's related to it, what supports it? And then that's an analysis in and of itself, though I do appreciate the importance of that. I think we need a brighter line.
Kristen,
Kirsten.
when you and I spoke, you said something that made me think that that brighter line wasn't too hard to get to. Do you, can you repeat that?
Kirsten, you're muted.
Oh, I'm sorry. I'm just first trying to make sure that I understand part of what Brooke just said. So Brooke, in the example of you've got a residential subdivision and some of the houses are on the parcel but not within tier 3, and maybe you've got a house that is in tier 3. From your perspective, would it make sense to also include, let's say, the driveway and the wastewater system that are located, near the house in tier 3, but not directly in tier 3? Like from my perspective, you would include the use that's in tier 3 plus the supporting infrastructure. So that's what I was envisioning, but I wasn't envisioning that Act 250 jurisdiction would be triggered over the entire residential subdivision, where located beyond tier 3, that is not also like supporting the primary use where located in tier 3. Maybe I'm not explaining that completely well, but
I think that makes sense.
Yeah. Okay.
Kirsten. Yeah.
Yeah, but then that makes the whole project as if it was in tier 3. And, if we're not going after the parcel, if we're going to be confining this just to the tier 3 area, to me, sure, the rest, you can't get there. You can't use whatever you're building in tier 3 unless you're able to drive on a road to get there. But I don't see that as, I think the brighter line is we're trying to protect the resource. So what does it necessarily matter where the driveway is if it's not a jurisdictional thing?
So what would you do? I'm just gonna throw another. What if the house is on the line? Like you got a house and half of the house is in tier 3 and half of it's not in tier 3. What are we gonna do then?
Then the house. Yeah, the house. They can't keep it out of tier 3.
So part of the, so we would review and have Act 250 jurisdiction apply to the whole house, even the portion that we're not located in tier 3.
I would think so. Anything that's part in is in. Anything outside the line is not.
Well, so a septic system, for instance, is connected to that house which is in, and there's a pipe. I don't know about driveway, but there are aspects of developing a house site that are directly connected to the house.
Yeah, but Brooke's point is a really good one. I like what you're saying, Brooke, is because I think when I was thinking through this, I was thinking from the other side standpoint, which was, the examples Kirsten was giving. But your point is like what we should be concerned about is the impact on the resource. So if you're not in the resource, the fact that your infrastructure is connected to something that doesn't mean that it has to be reviewed. Because it's the resource we're most concerned about. But Kirsten, you have the most operational knowledge of Act 250 review. If we don't review all critical aspects of a development, like a residential development, is the review itself become very problematic or compromised because you can only get to look at pieces of it?
I think that you could run into situations where it's a little more complex because, maybe you've got a multi-use structure and part of it is in and part of it's out, and now you got to figure out, okay, well, we're on the footprint and the floor plan of that building, you know, where do the impacts, like, maybe there's traffic, like which portion of that building is the traffic generator? I guess I just do think that it could become, and maybe this is the outlier, right? Like, I think it will be the outlier, but I think we're going to run into this a fair bit with parcels that have tier 3 areas and non-tier 3 areas. And then we're going to have projects that occupy different land areas. I think people will be motivated to avoid tier 3 because tier 3 will obviously, you know, in many cases trigger Act 250 review. So it will be protective of the resource that way. I think, you know, all things being equal, people would probably elect to site their development outside of tier 3 if practicable. So yeah, I think that it makes sense to review just kind of like the whole use to the extent the primary, like I think of it in terms of like, well, what's the primary use, if you will, even though that's not really defined, is, you know, you're building a house or garage, or you're building something. Where is that? So if that part of the project is itself in tier 3, then you would review it and the supporting infrastructure. That's just, I see that as more straightforward than I've tried to think about, well, just doing like only reviewing the portion that's in tier 3. I think there could be occasional weird and unduly complex sort of, you know, outlier situation. But
Right, I mean,
Stormwater is
how
like
can you
that, right?
yeah, you may not be able to determine what is undue impact without considering the whole.
Yeah.
Though I mean, it sort of goes back to the other question that we just worked through, and that is, you know, well, I mean, we want people to avoid impacting tier 3. So we want their designs to avoid impact to these critical resources. And if we involve, you know, whole parcels, as Sarah mentioned, I would be worried about the kind of machinations that people might go through in their project design to, yeah. In any case, I forgot what I'm completely lost my train of thought, but it may be impossible to just look at something that only the portion that is within the tier 3 area without understanding what its purpose is and whether that is an undue impact on the tier 3 area. Brooke?
Yeah, I follow you. So then are we talking, all right, if any of your projects in tier 3, we review the project? I mean, that would be much clearer and easier than to try to figure out, okay, what else that's not in tier 3 do we have to look at?
Right.
That, you know what
So
I mean?
I think the trick is whether it's jurisdictional and that other, you know, whether other portions of the project are jurisdictional. And as Sarah pointed out, we don't want them to be jurisdictional if they're not in tier 3, right? But if something is partially in tier 3, like a house site in a much larger subdivision, how can we understand whether the impacts are undue, or how can we understand those impacts without looking at the broader development proposal?
Yeah, and I'm trying to, in my brain, go through one to try to figure out how that would work. So as I've been standing here thinking, it's like, all right, so what if you're addressing criterion 8, aesthetics? Because you have something that's in the critical resource area, so it's jurisdictional. And you want to say, well, we, you know, put a bunch of, or, buffer trees or whatever. They're not in the tier 3 area, but they relate to a criterion about the project, and that's outside the area. So I think I'm now waffling.
Well, so I part of me sees this as you get what you what you deserve. If there was an idea that we might have a limited level of review in tier 3 areas. In other words, we would potentially not review projects in tier 3 areas under certain criteria that were not related to the resource being impacted. And our legal team said we don't have the authority to do that, and a bunch of other people said, and you probably don't want to do that. You want to have just a standard Act 250 review, right? Well, if that's where we have to be, which it is, I think it makes sense to say that the review is limited to the tier 3 area, right? You don't get to talk about the aesthetics of the road that you punched across the hillside to get to that house if the road's not in the tier 3 area and the house is, right? The aesthetics criteria applies to what's in the tier 3 area only. And the angry neighbor can't say, well, now I have to look at a road that crosses a hillside. Whereas maybe or other houses that are part of the project but are not in the tier 3 area, where maybe under a normal Act 250 review, those would all be considered as part of the aesthetics criteria, but not this time, right? This tier 3 is different. It's what you said, Brooke. It's about the impact on the critical resource. But you're right. We still need some way to sort of address the house split by the line, as Kirsten said, or the driveway split by the line or the road or what have you.
So we have we're over time on our agenda. We do have several items in our executive session, and we do have at least an intention to be finished by 4:15. So I just want to sort of take an assessment of how much longer we think our conversation will need to be on the tier 3 items. There are 2 more sections here that Alex has notes on.
Right. One of which doesn't require any conversation because we're legally not allowed to go that direction. So I think we could get through the next piece, the site specific resource delineation. My sense, Janet, is that 10 more minutes.
Okay, let's do 10 more minutes and then move on. Brooke.
I was just going to jump in on site specific. I agree with the recommendation, Alex, and Billy's memo, so I'm good with that.
Okay.
Did I see another hand? No. Okay.
Any other thoughts on the site specific delineation?
Just a quick question. When you say applicant driven corrections, I would interpret that would really be landowners.
Yes, the entity that is going to pursue the project in question.
But it could also be just a landowner wanting to make that petition, even well in advance of a specific, conceptual project, like the landowner.
Sure.
Okay.
And Alex, how do you envision these? Do you envision like planned updates? So we may be collecting these corrections along the way and then do a planned biennial update?
Question. No. So I kind of envision it like the FEMA letter of map amendment process, for those of you that are familiar with that, where FEMA says our mapping is very broad and sometimes there's a level of specificity with regard to a specific parcel where a correction needs to be made, but we're never going to reflect that on our maps because our mapping isn't meant to be, doesn't really go down to that level. And so I was not envisioning like collecting all of the adjustments that are made over the last 2 years and then updating our tier 3 mapping. Rather, I envision us updating our tier 3 mapping whenever ANR's base mapping that informed the tier 3 map to begin with, it changes in some way, that there's more accuracy or there's an additional data available or the like, such that these JOs or whatever vehicle it is that provides the site specific correction, sort of sit on the books in that fashion. And sure, we could consider them when we do have a larger update to make, but I wouldn't be doing updates driven by these site specific assessments alone.
And then do these updates have to go through the ICAR LCAR process?
Yeah, so you raised that question when you and I were chatting about this, Jan. It's a good one. I think we need to get the legal team's opinion on this. My sense initially is that they don't, that that if we write into the rules that tier 3 has this provision that allows for site specific changes, then we've accounted for it and it wouldn't require rulemaking to allow for a site specific change because the rules allow for it, if you know what I mean. ICAR and LCAR are going to review this and they're going to have to be okay with it in the first instance. So I don't think we would have to go back, and do rulemaking for every one of these. I think we can empower our program to do it.
Okay, and that is something that Rebecca Shalfo is looking into for us?
I haven't asked her to yet, but I'm going to based on your
just
comment.
Just to be absolutely sure.
Yep. Well, and your other comment when you and I were talking offline was who should be making these determinations and how should they be made? I was envisioning it being done by district coordinators because they are the ones that decide on jurisdictional issues in our program. But you had pointed out, there's no public hearing. It's one person. Maybe it should be district commissions that make this determination. I still think it should be coordinators, but I'd be interested to hear what others have to say on that.
And maybe also interested to hear what legal has to say on that. But let's pick on Brooke on this one to go first. What do you think, Brooke?
I'm sorry, I was reading an email on something that someone was just sending me. I did not catch your.
So who
apologize.
should be making these corrections? Who should be making these determinations to correct tier 3 boundaries? Do you think it is district coordinators? Do you think it needs to be district commissions? Do you think nobody should be making corrections? What are your thoughts?
I think I need to think about that one.
Okay.
I do not have an off the top of my head response to that.
Okay. How about you, Kirsten?
I'm not wed to any sort of particular path on this item. I think that the district coordinators could do it. I would envision that conceptually most of the time this wouldn't be a contested issue, that qualified consultant would bring forward the relevant information, that ANR would be reviewing that together with a consultant, and as a science it would hopefully, I think conceptually mostly be straightforward, with the occasional debate about presence or non-presence or what the site specific conditions were. So I think the coordinators could do it. I wouldn't put it on the district commissions. I think the board could perhaps do it. But maybe, and maybe ANR has some suggestions, but I think it makes sense to have a process to incorporate resource mapping adjustments. So like,
Okay,
this makes sense to me.
yeah. Sarah,
I agree with Kirsten. And I think just very briefly, Alex's recommendation in general, and I would hope that there aren't too many of these, but where there needs to be, I think it needs to be more focus on technical and expertise.
okay, Alex, you feel good with that?
Yes, and if no one has any parting comments on the last item about reduced review criteria, which our legal team told us we shouldn't go there, then I think I'm done for today.
Okay, great. Do we have any, somebody has raised their hand. Do you want to stop sharing, Alex?
Oh, right, yes,
Is that
that's
Bob? I can't
that's
see who it is.
Charlie.
Oh, it's Charlie. Okay. Charlie, go ahead.
Hi, thanks. So Charlie Hancock with FPR. I really appreciate the conversation today, especially around the logging and forestry exemption. The question I've got, a short one, probably not a short answer. The original draft included language around recreational trails and some proposed governance there. I don't see recreational trails referenced in this memo, and I wasn't sure if the board had any feelings, thoughts, directions on how they wanted to go with trails as they relate to Tier 3. I only ask because that's a area of interest for FPR.
Yeah, and Charlie, to speak to that a little bit, we have the existing Rule 51, is it? That addresses trails and just
Rule-
at least how they
71, yep.
71, sorry, thank you. And how the acreage is calculated, especially with regard to trails that span municipal and private property and the like. I don't think we as a board have gotten much further than just making sure that the Tier 3 rules are consistent with Rule 71. So I think it's still an open question as to whether we need to do more, address it more in Tier 3 jurisdiction.
Okay, appreciate that, Alex. Thanks.
I would say too, though, that linear transportation infrastructure, in my mind, was intended to include existing trails.
Did you
So
say was or was not, Alex?
Was. I think of trails as a linear transportation piece of infrastructure in the same way a road, driveway, sidewalk, or path, what it would be.
before we continue, can I just ask if Pete is in Montpelier in the 10 Baldwin office, or is it just Maddie today?
It's just
No,
me.
I'm not today.
Because I anticipate that we're not going to be able to do our executive session in 1/2 hour.
I can get down there if you need me to.
Can you get down there before a 1/2 hour?
Yep.
Okay, that'd be
No
great,
problem.
Pete.
Yeah.
Thanks. Okay, sorry to interrupt that discussion. Kirsten had her hand up.
Oh, I was just gonna say to Charlie, I mean, from my perspective, we would, in terms of when the board gets to the conversation about trails and Tier 3, we would, of course, welcome the input from ANR and FPR. So, but I'm not clear on what FPR's position is. Like, or, I'm not understanding.
Yeah, I
But,
think
and maybe
that-
you're not, if you don't want to talk about, I'm not trying to put you on the spot either.
No, I think happy to discuss it more. I think the overarching concern from FPR was that any recreational trail development within a Tier 3 area would trigger jurisdiction. So I appreciate the desire not to conflict with Rule 71. I think we can probably talk more. Your limited time today, so happy to chat some more about how things that aren't, in that middle of the Venn diagram might be at play. So again, I understand that you're limited for time today, so I'm happy to send you an email, Kirsten, and we can kind of chat more.
Charlie?
Great, thanks.
Okay, any other comments on Tier 3 before we move on?
Just thank you, Alex. This is a lot to get through. And I found your recommendations very technical, very thorough, and fully evaluated all aspects. So I appreciate the amount of effort you're putting into this and walking us through this.
Okay. Thank you, everybody, for persevering. And our next item is discussion of appeals enforcement and personnel matters. Brooke?
The board needs to discuss pending and probable Act 250 appeals and enforcement actions, personnel and staffing matters, and to have confidential attorney-client communications on these matters. I move that we find that premature public knowledge of these matters would place the board at a substantial disadvantage and that the board enter executive session.
Thank you, Brooke. That is a motion. Do we have a second?
Second,
Thank you, Kirsten.
maybe Sarah.
Oops, sorry, Sarah. And any discussion? Okay, all those in favor, please say aye. Aye.
Aye.
Aye.
That was 5 ayes. That is unanimous. So we will leave the public meeting for a time, conduct our executive session business, and then return to the public meeting before adjourning.